Good morning, everyone. We will go on the record. This is case CR 33-21-2230, State versus Pierre G. Lake. Mr. Lake is here present, represented by his counsel, Jim Archibald. The state is here. Mr. Wood, representing Madison County Prosecutor's Office, and Ms. Cole also in attendance for this hearing. This matter is a case that has been scheduled for trial in the upcoming week. However, the court's been advised that the parties have in fact now reached a plea agreement in the case, and the court has received and reviewed a copy of that plea agreement. Although I don't believe it's been yet filed in the case, but will be filed today subsequent to this hearing. So starting there, Mr. Wood, the state has entered into a plea agreement in this case and intends to go forward on a change of plea hearing, which would vacate our scheduled trial. Is that correct?
Yes, Your Honor.
All right, thank you. Mr. Archibald, of course, I'll have several more detailed questions for you and your client going forward. However, just to verify, you and your client, in fact, did review and sign this plea agreement in the case. Is that correct?
Yes, Your Honor.
Very well. And Mr. Lake, you also had a chance to read through that, and that's your signature on the plea agreement?
Yes, Your Honor.
Okay. Well, the court will consider then that the plea agreement has been filed. So, moving forward in this hearing, I will first note there is some media attendance here, which I have approved. However, the approval for any video or photography of this is limited to those parties that have received order from the court to do so. So anyone in attendance in the gallery, please don't use your phones or other devices to record in any way this proceeding. All right, the first thing I will do is go through the terms of this plea agreement. Given the serious nature of the case and the charges, I will do that in some detail. So the plea agreement is filed under Idaho Criminal Rule 11F1C, which intends to be binding upon the court pursuant to that rule. The court would note that the plea agreement first indicates that the defendant has been charged, and although the charge was through an indictment in this case, with the following counts. Count 1, murder in the first degree, a felony under Idaho Code 18-4001, 2 and 3A. The charging count 2 in the indictment is attempted murder in the first degree, and that's a felony in violation of Idaho Code 18-4001, 2 and 3, and Idaho Code 18-306. Count 3 of the indictment charges Mr. Lake, the defendant, with burglary. That's a violation of Idaho Code 18-1401. And finally, count 4 of the indictment is a grand theft felony. That's charged in violation of Idaho Code 18-24031 and 24071B. With those charges pending in the case, the defendant has agreed as followed in this plea agreement: to plead guilty to count 1, murder in the first degree, to plead guilty to count 2, attempted murder in the first degree. Part 3 of the plea agreement is a recommendation for a fixed sentence of 30 years of prison and an indeterminate sentence of life in prison under Idaho Code 18-4004. There's also a provision that the defendant would be required to pay restitution. In exchange for a plea of guilty and those recommendations, then the state would agree as follows: to dismiss the charge of burglary in count 3, to dismiss count 4, the grand theft charge, to make that recommendation of a fixed sentence of 30 years determinate and an indeterminate life sentence. And the court has discussed briefly before this hearing with counsel a clarification that that would be a recommended sentence that would apply to both counts 1 and 2 to be concurrent. Is that correct, Mr. Wood?
Yes, Your Honor.
Very well. The plea agreement further indicates that all other sentencing recommendations are free to be argued by the parties, including a fine, civil penalty, etc. and the defendant would be given credit for time served on this case spent in jail. And the parties do intend the plea agreement be binding upon the court subject to Idaho Criminal Rule 11. There's other provisions in the plea agreement which are commonly included. I won't walk through those specific provisions other than indicating there's a representation that Mr. Lake satisfied with the representation of his counsel, and I'll get more to that question here shortly. So, Mr. Lake and Mr. Archibald, is that your total and correct understanding of the terms of this plea agreement?
Yes, Your Honor.
Very well. I'll have some questions moving forward now for Mr. Archibald. Mr. Archibald, this case, I know, has been ongoing for just right about 2 years now. During that time period, do you believe you've had enough time to discuss all aspects of this case with your client?
Yes.
Have you done everything you believe is in your client's interest in this case to protect his rights?
Yes.
Did you conduct discovery in this case and receive responses to those discovery requests?
Yes.
All right. Were you able to review and go through that information you received through discovery with your client?
Yes.
Have you filed what you believe are any appropriate motions in this case?
Yes.
Have you explained to Mr. Lake all of his rights and defenses and the consequences of a guilty plea on these counts today?
Yes.
Do you believe your client understands the ramifications of a guilty plea pursuant to this plea agreement?
Yes.
Do you know of any reason in your interactions with Mr. Lake, any reason why he would not be competent to enter a plea today?
No.
Very well, then, based on all the circumstances of the case, including the terms of this plea agreement, Mr. Archibald, do you consent to Mr. Lake pleading guilty on these charges?
I do, Your Honor.
All right, thank you, Mr. Archibald. Mr. Lake, at this point, moving forward, I will have some questions for you. You currently have the privilege against self-incrimination and the right to remain silent in this case. If we proceed forward with this hearing, I will be questioning you about the case and requiring responses. I would require you to submit those responses under oath, so you would end up waiving or giving up your right to remain silent for this going forward. Do you understand that?
Yes.
All right, and I will also note, Mr. Lake, that would mean if you chose to withdraw your plea at a future chance, those statements could be used against you in future hearings. Do you understand that?
Yes.
All right, if you're willing to do that, then if you'll please raise your right hand, I'll have you placed under oath.
You do solemnly swear that the testimony you will give in the cause now pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you, Mr. Lake. Starters, Mr. Lake, we've got you with your name, Pierre G. Lake. Does the G stand for something? Is there a middle name?
The green.
Okay, thank you. Let me just ask kind of a general question, Mr. Lake. Do you feel like you're thinking clearly this morning?
I do.
And you've been in custody now for roughly 2 years, is that correct?
Just over 2.
Okay. Are you currently under the influence of any kind of alcohol or drugs right now?
No.
Do you take any sort of prescription medications that could interfere with your ability to think clearly?
No.
Are you currently on any kind of probation or parole in any other case?
No.
All right. Have you been diagnosed with any kind of psychological or mental problems that could impair your ability to think through what we're doing today?
No.
All right. In terms of the counts in this case you'd be pleading guilty to, Mr. Lake, the first count under count 1 is murder in the first degree. That does carry a penalty of a maximum of up to prison in life and a minimum 10-year prison term period if you were convicted at trial. Do you understand that?
I do.
All right. The way count 2 is charged in the indictment, Mr. Lake, is attempted murder in the first degree. That crime carries a penalty of up to 15 years of prison, and if the weapon enhancement is applied, can add an additional 15 years for a total 30-year sentence on count 2. Do you understand that?
I do.
Mr. Lake, the plea agreement, let me just go through that. Do you believe you have had adequate time to discuss each and every term of that plea agreement with Mr. Archibald?
I do.
All right. Because it is a plea agreement that's binding on the court, if accepted, I'll go through the following admonishment to you, Mr. Lake. Do you understand that if after reviewing the pre-sentence report and other evidence in the case, if I determine that this agreed upon sentence in your plea agreement is not appropriate under the circumstances, I would allow you to withdraw your plea and still set the case again for trial? Do you understand that?
I do.
All right. Mr. Lake, have you had enough time to discuss the case with Mr. Archibald?
Yes.
Did he share with you information he received through his investigation of the case, for example, police reports and other documents that the state provided?
Yes.
Is there anything you asked Mr. Archibald to do that you believe he's failed or refused to perform?
No.
Are you fully satisfied with the representation you've received from your attorney?
Yes, I am.
Mr. Lake, has anyone coerced or pressured you into pleading guilty today?
No.
Other than the terms of your plea agreement, has anyone made you any kind of promise about what your sentence would be in this case?
No.
Has anyone intimidated or threatened you or offered you some kind of a reward for your guilty plea?
No.
Is it correct for me to conclude then you're pleading guilty freely and voluntarily?
Yes.
Okay, Mr. Lake, the next thing I'll go through is a pre-sentence investigation report, which will be ordered in this case. The court will order a pre-sentence investigation report, and I'll advise you of the following rights you have as it relates to that. Number one, you will have the right to consult with Mr. Archibald when you're answering the questionnaire to get that report prepared. Number two, the court would require you to cooperate with an investigator who's going to be writing or preparing that report. And number three, the report will have confidential personal information about you, so it will be sealed in the case and not available for public access, and it will remain sealed, only available to the court and the attorneys in this case. Do you have any questions about that report?
No.
Okay, Mr. Lake, then by pleading guilty in this case, as I already mentioned, we're not going to have a trial in your case. You're waiving or giving up your right to trial. Do you understand that?
I do.
You understand, Mr. Lake, that means also you're waiving your right to confront your accusers, present evidence of your innocence, and the right to remain silent.
I do.
Finally, Mr. Lake, do you understand by pleading guilty, you'd become a convicted felon, so you would lose certain rights, including the rights to vote, to serve on a jury, to hold public office, and the right to bear arms?
I understand.
All right, at this time I am going to move forward with taking the plea in the case. Before I do that, Mr. Wood, let me just inquire from the state, given that this is a plea agreement that has proposed binding terms, has the state had an opportunity to review and detail the terms of this plea agreement with the victims in this case?
Yes, Your Honor, we have. I would know throughout this process, we met quite a bit with Ms. Bryan, who is the wife of the deceased and who is the victim of the attempted murder. We have gone over the details of this plea agreement and what we'd be asking. I would note, I think Ms. Bryan has a right to have this known. There are certain aspects of this that I think that she would prefer to be otherwise. Having said that, we have explained to both Ms. Bryan and her children, who are also victims in this case, the reasons for why the state is moving forward with this plea agreement.
All right, thank you for that representation, Mr. Wood. All right, this time then on these two counts, Mr. Archibald, I'm going to ask your client for his plea. Before I do that, however, are there any final questions, Mr. Lake, that you have for me or anything you think you need to discuss in private with your attorney?
No.
Very well. Then on count one, in the indictment charging you with the offense of murder in the first degree, on that count, how do you plead?
Guilty.
On count two, attempted murder in the first degree, how do you plead?
Guilty.
Okay, Mr. Lake, in order for me to determine whether or not there's a factual basis for your plea, I'll have some additional questions, starting now with count one, which is the count of murder in the first degree. The indictment alleges that on or about the 20th of September 2021 in Madison County that you did intentionally, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ralph Edward Brian by shooting him with a firearm. Let me ask you about the details of how that's alleged. First of all, do you agree that what you did occurred on or about the 20th of September, 2 years ago roughly, 2021?
Yes, I agree with what I'm charged with.
All right, Mr. Lake, were you in fact in Madison County when that occurred?
I did.
Do you agree with the language of the indictment that you did intentionally, unlawfully, deliberately, and with premeditation, and with malice aforethought, kill and murder Ralph Edward Brian?
I do.
All right, and did you kill him by shooting him with a firearm?
I did.
All right, and just one question or two for Mr. Archibald there. The language of the indictment goes through some legal terms that I went through. Could you explain the meaning of those terms to your client?
Yes, Your Honor.
All right, thank you, Mr. Archibald. The court does find and is satisfied there's a factual basis for entry of the plea as it relates to count one. Next, moving on to count two, Mr. Lake. On that same date, it alleges that Pierre Lake, on or about the 20th day of September 2021 in Madison County, Idaho, did intentionally, unlawfully, deliberately, with premeditation and malice aforethought, attempt to kill and murder Karen Chapel Bryan, a human being, by stabbing her in the face, neck, and arm with a knife. So on that count, Mr. Lake, do you again agree that this would have occurred on or about the 20th of September 2021?
Yes.
And were you in fact in Madison County, Idaho when this occurred?
Yes.
And did you intentionally, unlawfully, and deliberately, and with premeditation attempt to kill and murder Karen Chapel Bryan by stabbing her in the face, neck, and or arm with a knife?
Yes.
Very well. Mr. Archibald, again, did you explain to your client the meaning of those legal terms within the language of that count?
Yes, Your Honor.
And you believe he understands the meaning of those terms?
Yes.
All right. Well, the court is satisfied then also based on the admissions here today that Mr. Lake, there's a factual basis under count two as well. So the court has found the defendant today competent, that he understands the nature of both the offenses he's pled guilty to, understands the consequences of a plea on those counts. I'll also find that Mr. Lake understands and consents to the terms of this plea agreement, that there's a factual basis for the guilty plea on each count, and I conclude that the plea has been entered this morning knowingly, intelligently, and voluntarily. The court will accept the plea on both counts. We'll order the clerk to enter those into the record. We will schedule sentencing on this case January 29th, 2024 at 1:30 p.m. And in the interim, the court will order, pursuant to Idaho Code 1925-24, that a pre-sentence investigation report be prepared. Counsel, once that report is done and completed, the court, of course, will review it. If I have issues regarding the binding nature of the plea agreement after review of the PSI, I will contact counsel to discuss that. And otherwise, we will move forward with sentencing on January 29th at 1:30. I believe that concludes the matters we need to take up on the case this morning then. Mr. Wood, is there anything further from the state this morning?
No.
Thank you. Mr. Archibald, anything further from the defense?
No, Your Honor.
All right. That will conclude conclude the hearing. Thank you all of those in attendance for your conduct this morning during this proceeding, and the court will be in recess.